Okay, so I'm opening up the webinar now, so we might get people joining us. Good morning. If you're joining us, you're very welcome. We're just going to wait for a couple of moments and allow everybody else to get logged in, and then we'll make a start. Thank you. Good morning, you're very welcome. We're just going to wait another couple of moments. There are still people logging in, and then we'll make a start. Okay, good morning. You're all very, very welcome to the latest in our series of webinars kindly provided to us by Selig, our legal patrons. Today's session is on succession planning for business owners, really important topic given the number of family businesses in Northern Ireland construction and the importance, I think, of thinking ahead as to what to do if you're thinking of retirement, stepping back from the business, planning for all eventualities. So we're delighted, as I say, we're supported by Selig. This is only the latest in a range of webinars we've done all year. Those are recorded and they're available to you on our CEF YouTube page. I'll introduce you this morning. Fiona McFall is partner of private client of Selig, who's taking me through this, supported by Glenn Watterson, who's partner in corporate in Selig. And I'm going to be talking, I think, for about 40 minutes, 45 minutes, and then taking questions and answers. So throughout the webinar this morning, if you hover at the bottom of your Zoom screen, you'll see the Q&A function. We're probably all familiar with that now, so please feel free, pop your questions into the Q&A. Those are anonymous, and I will share those questions for our Selig colleagues at the end of the session. So we'll be doing the Q&A at the end. We'll also be recording the webinar. It'll be available to you afterwards, and I know the team from Selig are always happy to follow up with any queries you may have. So with no further ado, I'm going to hand over to Fiona, who's going to take us through the early part of the session this morning. Fiona, good morning to you.
Good morning. Good morning, everyone. Thank you all for joining this morning's webinar. Before I begin today's talk on succession planning for business owners, I just would like to say a little bit about Selig. At Selig, we are proud to say that we are local and independent law firm. Our lawyers are all our experts in matters of corporate and commercial law, and we offer comprehensive legal advice, irrespective of how complex that matter is. Our 360 approach means that our clients and you have access to our specialist team who can provide you with tailored solutions to all your legal issues. Most of our lawyers are, in fact, ranked in the Chamber's Guide, which is the UK's guide to the best lawyers. And earlier this month, in fact, we just had the prestigious accolade of winning the Corporate Law Firm of the Year at the Northern Ireland's Dealmakers Awards. So I'll now begin this morning's talk, and what we're going to look at is why it is important for you as a business owner to consider succession planning, in particular for you and your family, and also for the business. I'm going to then look at the key steps. What are the key steps that are needed in order to implement this planning for your future and for the future success of your business? I will illustrate the key steps by talking you through some case examples, and some case examples, however, just to note that all names are entirely fictitious. Well, why is succession planning required? In the famous words of J.K. Williams, failure to plan for succession is planning to fail. So successful planning is needed to protect both you and your business, both in the event of your death or in the event of incapacity. I see numerous High Court cases on disputed controllership matters and disputed wills. We live in a more litigious society, and it's become more common practice for families to dispute a will and also who is to receive, for example, the benefit of the shares in the business. Often, without any planning, you will have an outcome that doesn't reflect your wishes or the intentions of the business owner. It's also extremely costly and detrimental for the business and for the family. So, well, what are the key steps? What are the key steps that I'm going to be talking about today that really you as a business owner need to be thinking about? Well, the first thing that we all should be thinking about is putting in place an enduring power of attorney. And this is a document that I'll talk in more detail, but is a document that protects you in the event of incapacity. The next thing that you should be thinking about is making a will. In Northern Ireland, 68% of the adult population don't have a will, which is extremely worrying, especially, you know, given that is how your estate will be administered. If not, you're totally reliant on the law. This will obviously be the document that will deal with your personal assets and your business. The next key step that you need to think about is considering your inheritance tax liability, both for you as an individual and also for the business. So I'm going to look at relief for trading businesses and also what the inheritance tax planning that can be done for you as an individual. Fourthly, the protection of your assets. I'm going to look at the role of the trust can play in that inheritance tax planning. And also I'm going to touch on planning for long-term care. Again, this is something that none of us like to think about, but again, it's a very important area. Finally, my colleague Glenn is going to look at the role of a shareholders agreement and a cross-option agreement. And obviously this is extremely important for any business in Northern Ireland, including obviously family business. So moving on to the first key step, which is an enduring power of attorney. So what is an enduring power of attorney? As I mentioned there, it's a document that allows you to appoint someone you trust and someone who is financially competent to manage your affairs, both your individual affairs and your business affairs in the event of incapacity. The relevant legislation is the 1987 Northern Ireland, it's the Enduring Powers of Attorney Northern Ireland Order. So having this document in place would allow those individuals that you trust to really act swiftly and to ensure the seamless running of your private affairs and also your business affairs. As we all know, the business can't operate without someone having the requisite authority to sign documentation. If that person loses capacity, not only will there be difficulties in signing, there will be decision-making stalemate. So it's extremely important to have that document in place so that we're not reliant on the process of appointing a court-appointed controller. I had a case where I was asked to act as an attorney for a client, and within a matter of a couple of months, the lady had been at her. The client was in their property in France. Selig were dealing with a property transaction on the client's behalf, and it was very close to completion. Unfortunately, the client became extremely ill and was unable to sign the documentation. The fact that I had been appointed as one of the attorneys meant that actually I could sign the paperwork in order to complete the property transaction. So it was extremely beneficial, and we got the matter over the line, which the client was actually delighted with, especially once she was well, and appreciated just the significance of getting that deal done. Okay, so well, what happens if there is no enduring power of attorney? Unfortunately, if you've no enduring power of attorney, you're reliant on a court application, normally by a family member, to become your controller, your court-appointed controller, and that will give that individual, the power to deal with your property and your financial affairs, including those involving the business. The problem is it's a lengthy, drawn-out process to appoint a controller. The minute it takes the court, it's taken the court 2 to 3 months. It's also about 10 times more costly than putting in place an enduring power of attorney. And it can also result in tension within the family and the business regarding who should be appointed. I'm going to take you through an example case that I've got involved in, where I've actually been appointed as the controller for the client. And this is a case that involved a very successful family business in Northern Ireland. We'll call the client Mr. Burns, the fictitious name of Mr. Burns. So we have 3 shareholders, including Mr. Burns, who is no longer able to manage his financial affairs. He has capacity, but again, it's very difficult for him to manage, given his age and his deteriorating health. So no enduring power of attorney, and there's a long history within this family of them not getting along and seeing eye to eye. So there was certainly a lack of trust between the children who are the shareholders and the other children who weren't involved in the business. There were also allegations made to the court regarding the misconduct of shareholders. I was then appointed by the court to firstly to investigate the allegations that were made by other family members, and to deliver a report to the court. And then following some recommendations that I made, it was decided and agreed by the court that I would be appointed the controller for Mr. Burns. So I would be responsible for making all of his decisions regarding his personal affairs, and also I would have a say on his behalf in respect of the family business. So obviously it would have been better for that family not to have to consult me, regarding all of their decisions. For example, I was on the phone last week to their accountant regarding some of the business matters, and regarding loans and some finance issues. So it really, things would have been a lot easier for that family had the client chosen someone he trusted to make his decisions, and would have avoided the need for a court-appointed controller. Okay, so the next step that you should be thinking about is making a will that will deal with not only your personal assets, but also your business assets. So a will ensure that your personal assets and the business is distributed to the people that you intend and that you want to benefit from your estate on your death. As most of us today know, that obviously a will is a legally binding document. It allows you to appoint people you trust that can be your executors, who can be responsible for overseeing the distribution of those assets. Again, it allows you to pick people who have a commercial awareness, an understanding of your intentions, and also an individual that you believe will take a sensitive approach at what's a very difficult time, and hopefully help avoid any family conflict which can arise at the point of death. So the role of the executors in your will is extremely important, because they're the individuals that will be involved in the winding up or the sale or the transfer of the business. They will be the individuals that will sign those stock transfer forms once the grant of probate is proved or is issued by the court. So again, if a business is to continue, the will can express that intention and set out how you envisage the business to continue on your death. I got instructions just about a year and a half ago to come out and see a client who was terminally ill. The client that we'll call Mr. Jones had a construction company, and he had various other commercial and personal assets. In fact, there was actually ongoing litigation as well over some land disputes. So again, there was a lot of matters going on in the background to make this to make things challenging for this business owner. So we had limited time in order to put in place to implement a strategy. We had a meeting with there was a tax advisor, myself, his accountant, and we were looking at what options we had in order to mitigate a significant inheritance tax liability. I'll not get into the nitty gritty of funds that were due back to the estate because of some difficulties in the business in the past, but ultimately, as things stood, there was going to be a £3 million tax liability. So what we managed to do, I didn't know whether I had maybe weeks or a couple of months. So again, I had to act swiftly. So what we did was we managed to put in place a will following a quick turnaround of marriage. Unfortunately, this gentleman had a long-term partner but wasn't married. So there was a marriage which allowed us to get the spousal exemption. And then what we did was we structured his will in such a way as we maximized the relief that we could get in respect of the business. And we also relied on the fact that we were going to be able to get spousal exemption on other assets. And we managed to save the £3 million in tax. So again, we had lengthy discussions with the gentleman, and were able to mitigate that significant tax liability. If he had died without the will being put in place, or without the marriage having taken place, there was that £3 million of tax liability. And now what we've been able to do is secure the assets for the deceased intended beneficiaries. So he since passed away. He passed away about 4 weeks after I put the will in place, and and obviously then things have been running smoothly in order to provide for his intended beneficiaries. Okay. A will also provides a means of capitalizing on the business relief. If those business assets are left to children and to grandchildren. I just mentioned the spousal exemption that most of us probably are aware of. One of the advantages of being married, and it's certainly by structuring the will in such a way that you are considering what the inheritance tax liability is in relation to the business. Is it a trading business? Is it going to qualify for relief in its entirety? Are there investment properties that maybe aren't qualifying? Is there a car park, which I saw in a case where, that wasn't going to qualify, that has significant value? By looking at the assets and actually having a look at those values at the date that the will is being prepared, this will allow you to, to structure it in the correct way in order to mitigate any potential tax liability that is due. So I'm going to just talk you through an example of some recent planning that I did for a client. So we'll call the client Mr. Carson. So there was a client, the estate's worth sort of 40 million, trading business in London, but a lot of personal assets as well that sit outside the business. So as well as putting in place wills for this client who never had wills, despite the value of the estate being significant, we were able to look at things very closely and look at what strategy would allow not only an outcome which is best for the business and passing that on to the next generation, but also an outcome that would allow the most favourable inheritance tax position. So what we've done is we've also looked at not only the will, but also the use of trusts, so that other properties could pass on to children and grandchildren. Now, obviously, there had to be quite a complex, calculation in terms of capital gains tax. But again, that exercise, we were able to take that exercise on in conjunction with the tax advisor, because the client came to us to look at their will in the first instance. So it certainly it shows how important it is to make that step of making your will and having a closer look at those assets. Well, what happens? Many people say to me, "Well, Fiona, surely, I've got a wife. There are other shareholders. Surely those things just pass, to my wife and maybe the other shareholders." Unfortunately, in the absence of a will, you are completely reliant on the law of intestacy. The law of intestacy is governed by the Administration of Estates Act. It's a piece of legislation that was drafted in 1955, and it's pretty much, it's very out of date. It has been amended once in recent times to increase the statutory legacy, which is the amount that would go to your wife. So people are under the assumption that the wife would, if assets were in an individual's sole name, that they will all go to the wife. But ultimately the wife will only be entitled, in respect of those assets, the wife will only be entitled to a statutory legacy of a fixed amount. Where there are children, it's 250,000. So for example, if you had a property in your sole name that was worth $500,000 and you were reliant on the law of intestacy, the wife would only be, your wife or husband would only be entitled to the first £250,000 of that property. The next example that I'm going to talk you through demonstrates how this became a problem for this client. They only came to me, the client came to me once they had a problem, and the gentleman had already passed away. So there was a construction company. The client died prematurely. He was in his mid-40s without a will. There was some property and assets in his sole name. And as I mentioned, the wife was only entitled to a statutory legacy of 250,000 and a portion of the residue. This meant under the law of intestacy, the minor children were actually entitled to a share of the family home. So never mind the issues regarding the business and the fact that there was no will, although the gentleman effectively was the business. But you also had this problem where, you'd minor children entitled to a portion of the family home. No, they can't, they're not in a position to give consent to vary that in some way. So obviously that became a problem for the wife, who would obviously want the freedom to be able to move house, dispose of it, downsize, and do whatever was required. So again, it was obviously very challenging and difficult for her at a time that she was obviously grieving and then having to deal with all of these other issues because of the absence of a will. I've just touched on the importance of inheritance tax planning, but what I would say is the next step that you should be thinking about is, what is my inheritance tax exposure, both as an individual and as a business? Most people, especially business owners, will have acquired significant assets over the years, certainly before their retirement. Well, obviously, some of us will be thinking, well, you know, it's a trading business, you know, there'll be relief from inheritance tax. And obviously that only applies to the assets within the trading business. Other assets, including commercial property, residential property, any investments or bank accounts, will be chargeable to inheritance tax at the rate of 40% above the inheritance tax nil rate band. And that inheritance tax nil rate band currently sits at 325,000. I mentioned obviously the spousal exemption that you can get when on first death, when it goes to your husband or to your wife. But it's when you're passing that on to the next generation, that's where it becomes problematic. And sometimes you don't have a lot of time between first death and second death. So sometimes you don't have the 7 years to try to for the surviving wife or husband to try and get rid of those assets on to the children. So really you need to certainly look at the what your current exposure is to inheritance tax at a very early stage. I'm going to just talk through an example. It's actually a case that I'm currently working on, and it is a case where I was instructed by the executors, who were reluctant to actually to take on the administration of this estate. They didn't know a lot of the detail regarding this gentleman's assets. So they were long-time friends. They were not family members, and ultimately they knew the estate was significant, but just didn't know obviously to what extent. So planning, this gentleman had a will, but he hadn't implemented any inheritance tax planning. He had went to a sort of a small practice, who obviously followed his instructions, put in place a will, but there certainly appeared to be no discussions or measures taken to mitigate tax. The result was, when I gathered information regarding the assets, wrote off to the banks, looked at all the financial matters, the reality was the estate was so significant that the inheritance tax liability was 2.6 million. That gentleman was in his early 70s. He maybe thought he was going to live a lot longer. He had maybe a bit more time, or maybe he wasn't. Maybe he wasn't that worried about HMRC taking 40%. So, what we have been able to do is, I have had discussions with the main beneficiary, and we have looked at we put in place what's known as a deed of variation. Within 2 years of someone passing away, if the beneficiaries all agree, you can actually vary the will, and that can be a useful tool when you're looking at some inheritance tax planning. It's really a last resort. What we managed to do is we managed to leave some money to charities, which is exempt. But what we have, and furthermore, we the main beneficiary is elderly herself. So what we've managed to do is create a trust in that deed of variation. So we will, if she was to pass away, whatever the value that we have put into the trust, we will save the tax on that. If she was to die tomorrow. Thankfully, the clients were in with me a couple of weeks ago, and we've got that trust the deed of variation executed with the trust included. So at least I have peace of mind of knowing, although the 2.6 million or slightly shy of that was paid in respect of the the deceased who didn't do the planning, at least his main beneficiary has now taken advice from us, and at least I know that there's not going to be another 40% if she was to die in the very near future. Okay, so trusts and inheritance tax planning ensure that assets are distributed to the parties that you wish. It also helps you reduce, as I mentioned, the inheritance tax liability, which is a real burden. Remember, that's a real burden on your executors. If your executors are your children, they're trying to find the money in order to pay this tax, and unless there's insurance in place. So it really puts people in a really difficult position if they're the ones that are trying to deal with HMRC and try and work out what assets they need to dispose of in order to pay the tax. The revenue won't wait as well. They put a lot of pressure on you to pay within a certain time. Otherwise, interest is obviously starts accruing. So on that liability. There's also a significant risk. There's also a risk of a significant inheritance tax liability, even if you have a trading business. So a lot of people are under the assumption, oh, it's a trading business, there'll be no inheritance tax liability. Well, look, the case that I'm going to talk about, we'll call Mr. Casey, demonstrates how a trading business can also face some exposure to inheritance tax. So this is this was a client who had in place a will, husband and wife had in place a will, planning was done so that some of the shares would pass to the children on first death. And the difficulty was what the solicitor didn't know, or what the tax advisor, I don't believe knew, was that gave the original advice, was the extent of the cash in the business. And this is becoming more and more common for HMRC to challenge this. So in this case, there was £5 million of cash in the business, and HMRC said, "You're not getting relief on this. This is basically the holding of an investment. You don't need £5 million in cash for your product or for your supply, or for new premises. You need to pay us the 40% tax on this." So in this case, I got involved when it became problematic with a leading tax advisor, and we challenged that decision. So after there were affidavits filed regarding other premises that we were negotiating the purchase of, there was, as I say, there was numerous affidavits and a long-running battle with HMRC. And we provided evidence, case law regarding, the amount of cash a business of this size was allowed to hold. In the end, we were successful. The gentleman, the tax advisor, was actually former HMRC, so he was excellent on what they would accept and what they wouldn't accept. So it just so happened that the group that was dealing with it on this particular occasion wasn't willing to accept it. In the end, they were forced to, and our challenge was successful. And we provided, obviously, evidence that supported our case. So the client was delighted with the outcome, and we got the relief. But again, it really highlights to all of us that how important it is not to just rely on the fact that it's a trading business. There could be other assets within that business, including cash or other properties, that really, strictly speaking, aren't used as part of the trading business, and you may not get relief. So I've been recently working with a client, and there was a lot of cash in the business, and we looked at it more closely to make sure that we wouldn't have that difficulty. Okay, so it's something to be very aware of. Actually, just at this point, when I'm talking about a trading business, people sometimes assume that their particular business will be qualifying, and obviously this is construction. But again, I did see a case where a client believed that a caravan park was going to be qualifying, and obviously it wasn't. So again, it's certainly worth looking at your business and making sure that all of those assets will be granted the relief. The next important step is really looking at the role that trust can play in your estate planning. So despite the taxation of trusts, they do remain attractive for business owners who have significant assets and they wish to mitigate their potential inheritance tax liability in order to obviously to protect the family and to protect the business wealth. There are different types of trusts that we use. We use discretionary, we use bare trusts, and they certainly should be considered by all business owners. I have had numerous business owners that have managed to successfully protect various assets, in particular assets against divorce, where they have made use of trusts where appropriate. So it's not just about inheritance tax in terms of trusts, it can be other protection that is needed for the business or for the family regarding, for example, divorce or vulnerable beneficiaries. So really, it also trusts allow the business owner to place the assets outside of their estate. So at the date that trust is created, that's starting the clock, and you're looking at those assets been outside of the remit. There could be 10 yearly charges if it's a discretionary trust, but certainly in terms of what we look at as part of your estate, you're really placing those assets outside. It also provides flexibility about your intended beneficiaries. So if, for example, you are thinking, well, my children are young, I have no idea how they're going to turn out. Hopefully they will be very successful and level-headed, but again, none of us know that. So trust can provide a place to allow us to, for example, control assets, have them outside of our estate, but have maybe the children as the potential beneficiaries, and we've got that little bit of flexibility that if we need to maneuver on some of those assets going to them, we have that as an option. So clients will typically use properties, shares in trading companies, as assets that may possibly be transferred to trust. Only last week I had a client that's buying a property for his son for 600,000. He's in his early 20s, and he decided to use a trust because, again, he doesn't want his son to go and remortgage that property. He doesn't want the son's girlfriend to move in and to have a claim. So we've decided to use a trust to protect that asset at this stage. Okay, so trusts, as I say, are a very useful vehicle. They are also a useful vehicle in terms of planning for long-term care. Now, again, long-term care isn't really a major concern for anyone with significant assets, because the reality is we're all going to have to, most of us are going to have to fund our care. However, we may have an elderly relative who where their only main asset is maybe the family home. So in those sort of cases, if you have an elderly parent, an elderly relative that really wants to protect their house, that a trust can obviously play a role in that. So again, most people are going to be faced with the prospect of funding our care. And again, I just wanted to highlight, although it may not be relevant for someone that's got a huge pension pot or has significant other personal assets, paying £950 a week may not be too much of an issue for some people, but for others it is significant. So again, it's just to highlight that there is, I think we should certainly, as individuals and as business owners, consider, what is our position in terms of long-term care? Are we going to be funding it ourselves? Or are we thinking that it's something that we may be reliant or wish to rely on the state for funding? So I've just highlighted that really, any assets over 23,000 is going to be deemed to be, you're going to be fully funding. So what we often do is we will place, for example, the family home and maybe a second property in trust. where, for example, most of the cash assets or the business assets have already been transferred. So maybe what you're left with is, is a couple of properties. So there is measures that can be taken in order to protect those assets, so that they're not sold in order to fund your care. Okay, and then I'm moving on. So my colleague Glenn is going to talk about the role of a shareholders agreement and cross-option agreement. So he's going to look at the importance of having these in respect of your succession planning. Oh.
Thank you, Fiona. So as Fiona said, my approach here is from a corporate law perspective. Obviously, as Fiona's gone through how to manage your succession and deal with your assets on death and ahead of death, there's some complications that arise when you're talking about share or security assets. Companies' articles of association, shareholders agreements, if the company has one, obviously has binding obligations and is a binding contract on the company and its shareholders. Therefore, if there's any sort of restrictions or prohibitions or even enforced transfer provisions in those constitutional documents, that will override a will. So, for instance, preemption rights, which a lot of people may be familiar with as directors and shareholders, if the shareholder is going to transfer the shares, then you'd be offer them to the other shareholders first of all, or buyback by the company before they can transfer their shares. Otherwise, a shareholders agreement is integral to effective succession planning for shareholders, and it really does need to be, particularly in a family business, reviewed in line with the will, and for non-family businesses as well. The approaches will vary. With family business, there sometimes will be more restrictions on keeping shares within the family, and shares can't be transferred up to them within that sort of family or larger family group. And there will be differences of, I suppose, the objectives there. And as I said, we need to make sure that, something you may think is being done with your will, transferring shares or dividing shares among people, can be done as you intend to be done. It's not overridden by any provisions within the company's constitution. So a lot of you are probably aware of what a shareholders agreement is. A lot of the provisions within a shareholders agreement and the articles of association aren't really don't have that much of an effect on succession planning. But the shareholders agreement, it's a contract that's entered into between all the shareholders of the company and normally the company itself, which governs the relationships between those individuals and what they can and cannot do with their shares, or how the business is operated. It's pivotal in protecting shareholders' interests and enables certain shareholders to have more input or control over board of directors, who are, from a corporate governance perspective, the people who run the business day to day. Together with the articles of association of the Companies Act 2006 and the Shareholders Agreement form the rules and requirements in which a company operates, in which directors and shareholders are required to act in relation to each other and the company. I've just noted there that the Shareholders Agreement would be where we would put in a lot of the transfer provisions they're a little bit more private, because it doesn't get filed in public record like a company's articles of association would. So if there was particular people that shares need to be transferred to, or intricate arrangements that you wanted to document in relation to succession planning, the shareholders agreement would be the place where that is done. On the next slide, it says that just setting out what exactly is contained within the shareholders agreement. So there'll be rights for certain shareholders to appoint directors or change directors. The decision making will be sort of set out, and if certain shareholders have vetoes or need to consent to certain matters. The next two are things that we're particularly interested in when it comes to succession plan. That is restrictions on issue of shares and on the transfer of shares, and then an exit or withdrawal for the company. So that might be things like dragging along other shareholders if a majority want to sell the shares, and sort of what happens in that life-changing events of the company where there is a potential sale or death of a shareholder. Also, the shareholders agreement will contain restrictive covenants of shareholders and usually dividend policy. So, how the profits of the company over and above what's needed for working capital is dealt with. So in terms of succession planning, as I mentioned, shareholders agreement will typically, and the Articles of Association, contain restrictions on transfer shares and preemption rights. As it touched on, preemption rights, that sets out, if a shareholder wants to transfer their shares, they usually, particularly in a non-family business, will have to offer them pro rata across the other shareholders first of all, and there will be valuation mechanisms and things put in there as well. On top of that, we will permit certain transfers, and that's where it's very important in terms of succession planning, where a shareholder wants to bequeath their shares in a certain way upon their death. You would want to make it clear there that they can transfer into certain family members or put it into trust for the benefit of family members, or if it's anyone else, you would need to ensure there's nothing that restricts the shareholder doing what they want to do with their shares. From a non-family business perspective, it may be the opposite, where the shareholders want to ensure that in the event somebody else dies as the shareholder, that the shares are sort of kept amongst the existing shareholders. There will also be sort of compulsory transfer events, and again, there's a few objectives and aims here. So upon a death, you may say that the shareholder shares are offered up for sale. So there may be certain shareholders in a family business that we say, if they die, then they can transfer in line with their will, and that's just left open depending on what's on their will. It may be that on their death, they can only transfer to children or to other family members. Critical illness is another, which we'll touch on more when I talk about cross-option agreements. Then bankruptcy, fraud, gross negligence, and other events such as divorce. You'll want to have a mechanism in there that deals with the shares in the way that everybody agrees at the time when they're signing the shareholders agreement, to ensure that in a family business, maybe if one of the children is a shareholder and is about to get married to somebody they've only met a number of months before, there's different sort of controls and forced transfer events we can put in there to protect from an estate on a divorce. One other thing that I suppose as a first generation or a senior generation of shareholder, they would want to maybe retain control over successor shares. So if shares were transferred on to children or to other relatives, there we can include sort of options to purchase the shares back at a certain defined value, and that can be left open, that in case anything like a divorce, like sort of financial insecurity occurs, that there's an option that can be triggered there in advance to ensure the shares are brought back into the control of the sort of senior shareholders. In terms of cross-option agreements are really a way in which a tax efficient way to ensure that, look, upon the death or sometimes critical illness of a shareholder, that there's money there to ensure that a shareholder who has died or has become critically ill, their beneficiaries, their next of kin, their family members, get a value for that shareholder shares, and on the other foot, the continuing shareholders in a non-family business, usually they would want to ensure that they're not going to be left dealing with the spoils of a deceased shareholder who's going to be their shareholders in a two shareholder company where the people aren't related. Shareholder A has died, shareholder B doesn't want to be bringing in the spoils or the beneficiary of shareholder A and dealing with them from day to day, them taking money out of the company even though they maybe don't work in it and don't bring any benefit. So the cross option agreement basically puts in options where, upon the death of one of the shareholders, the next of kin have that option to force the other shareholder to buy the deceased shareholder shares, and also that the living or the surviving shareholder has the ability to force the beneficiaries to sell them the shares. They are typically backed up by death or critical illness insurance policies, if it is a critical illness cross option agreement as well, that sort of provides that the insurance policy pays out for the benefit of the surviving shareholder or shareholders to give that cash that's used to buy the shares, and then the next of kin are left with the benefit of a cash policy, and the surviving shareholders have the ownership of the business in full. But whilst we don't specialise or give out any tax advice, the cross-option policies, they are tax efficient, and they're designed and constructed in a way to retain business property relief on a transfer of the shares. We would always ensure that if you are going down the road of a cross-option agreement, that you ensure you have your tax advisor, us or whoever is lawyers, and the wealth manager, whoever you use for your insurance policies, all look at the policies and the cross-option agreement together, just to ensure that everything is lined up correctly. It's important, lawyers' job to review the articles in the shareholders agreement, just to ensure that the cross-option agreement does work alongside what's in the shareholders agreement, so they complement each other and they don't restrict one from doing what it's meant to do. To ensure, sometimes cross-option agreements are drafted where the company has the option to buy the shares back rather than being transferred to the other shareholders. So you just need to make sure there is that's permitted in the Articles of Association, and that the policies again are constructed in a way that is tax efficient and does enable the business property relief to be maintained. So in order to maintain that business property relief from inheritance tax, the two options that are contained in the cross option should run consecutively rather than concurrently. So the structure is usually that the surviving shareholder, so the spouse of shareholder A, first of all has that right to compel, sorry, the surviving shareholder has the right to compel the deceased shareholder's estate to sell the shares to them. And we may draft in that that's for a period of 3 months, and at the end of 3 months it just lapses, and immediately upon that lapse, the other option kicks in, where the deceased shareholder's estate has the right to force the surviving shareholders to buy the shares. And again, the policies are going to be there. They're going to be written in trust for the surviving shareholders, so the cash is there, so that nobody's putting their hand in their pocket or having to find funds that they may not otherwise have. I sort of touched on there, just from a tax perspective, again, we don't give the tax advice, but just so that everybody's aware, the cross-option agreement arrangements retain business property relief, as I said, and structuring it in the way that it is an option. It's not viewed as a binding contract for sale in the eyes of HMRC, which ensures that business property relief is maintained. It's seen as a right to buy and sell, not as an obligation. It's a key distinction. So I mean, that's everything from the shareholders' perspective. And look, I don't know if there's too many questions in the questions and answers, but if nobody has any questions at this stage, Fiona, my details will be on at the end of the webinar, and Mark can pass this on as well. So just don't hesitate to get in touch with us, because as it's a bit of a daunting sort of topic, where we're more than specialised to hand out the advice and even just talk through sort of certain situations. So don't hesitate to get in touch.
Tremendous. Glenn, thank you so much. And Fiona, yes, we actually have no questions submitted. That doesn't surprise me at all. This is a very complex area. I mean, the one thing that comes across without a doubt is that I think without dealing with these matters in a timely way, there's a natural human fear of what could go wrong. So there must be great comfort in planning the proper strategies. So yes, as you say, if anybody has any questions, and I'm sure there will be some, we'll be sharing a recording of the session and your contact details. And obviously CEF members know anytime they have an issue, they can lift the phone to Selig anyway on the range of topics. But no, that's been really useful, very comprehensive. I'm sure it's triggered a lot of thoughts. It'll take people a little bit of time to think, right, what do they need to put in place? But it's absolutely vital. It's vital for families. It's vital for business continuity as well. So really informative session. And as I say, just one of the latest sessions from your good selves at Selig, and we really appreciate your support as patrons of the CEF and all the good work that you do for members behind the scenes as well. It's really appreciated. So again, Glenn, thank you very much for your input today. Thanks everybody for logging in, and we'll see you next time for another CEF Selig webinar. But thanks very much for today. All the best.
Thank you.